After the Supreme Court overturned Roe v. Wade, abortion rights opponents and state governments quickly moved to ban the procedure, while abortion rights supporters quickly challenged the bans in court. The 1973 Supreme Court case established a constitutional right to abortion. Now, abortion rights will be left to states to decide, with years of litigation expected in state courts. One state abortion ban that has already been tested in courts, and so far prevailed, is a Texas law known as Senate Bill 8. It took effect last fall and relies not on the government but on private citizens to enforce. Opponents have couched it in terms like the vigilante abortion law or bounty hunter law. That's because the law incentivizes citizens with a cash bounty if they succeed in suing anyone who has helped a person get an illegal abortion. Texas inspired Idaho and Oklahoma to follow suit with this type of enforcement mechanism. Most states that want to ban abortion have so far not taken this approach, opting instead to enforce a ban through the criminal justice system. 24 states have now banned abortion or will soon. Still, for many abortion opponents, Texas-style laws remain an appealing strategy in the movement's fight to enforce the bans, said Mary Ziegler, a law professor at University of California, Davis, and the author of the new book Dollars for Life, The Anti-Abortion Movement and the Fall of the Republic. The anti-abortion advocates who developed the Texas law, she said, thought criminal laws in comparison offered fewer ways to survive court challenges and too much discretion to the more progressive prosecutors who might fail to enforce the law. For example, if you want to stop people from traveling. The same isn't true with these civil-style laws. SB 8 bans abortions following the detection of a fetal pulse, in other words, after about 6 weeks, which is often well before many women even know they are pregnant. The law makes no exceptions for rape or incest. It allows private citizens to file a civil lawsuit against anyone who knowingly aids or abets an abortion. If successful, the law instructs courts to award plaintiffs at least $10,000 in damages from defendants. Doctors and abortion providers, drivers who provide transportation to a clinic, or those who help fund an abortion, for example, could all be liable to incur legal fees if they are sued. People who receive an abortion cannot be sued under the law. The threat of lawsuits has so far been enough to discourage providers from performing abortions in the state.